Good.
Hello, my name is Dr. Davina Lloyd, and I'm a 1950s woman. And I've been talking a lot about CEDAW, the UN Convention on the Elimination of All Forms of Discrimination Against Women. I went to Geneva in 2019 to meet the CEDAW committee and to put the case of discrimination of women born in the 1950s regarding their pensions to the committee. With me today is the Honourable Dr. Jocelynne Scutt. Jocelynne is a former judge, an anti-discrimination commissioner, an expert in women's rights, and a stalwart campaigner against injustice for over 5 decades. Dr. Scutt has been involved for the past 3 years in the work to tackle the injustice and discrimination faced by 1950s women. She's produced reports from 2 people's tribunals and addressed these issues in those reports. She's also chaired 3 women's parliaments from Cambridge. Just a few months ago, she was a recipient of an award from the Iranian and Kurdish women's community for her work on fighting abuse and promoting women's interests. Welcome, Jocelynne, and thank you for joining us today.
Thank you, Dr. Good to be with you.
Your report in 2022 made it clear that 1950s women had been discriminated against, and that both national and international laws had been breached by the UK government in their treatment of 1950s women regarding their pension rights. Can you give us a bit of a background to your reports and your conclusions?
Yes. In 2020, the CEDAW People's Tribunal, which I chaired, identified the 1950s women issue as one that was directly relevant to CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women. At that time, 1950s women, of course, were aware that they had been unfairly treated by the change from 60 to 65 and then 66 in terms of receipt of the age pension. And coming out of that People's Tribunal, in 2022, July, another tribunal was held, which again I chaired, which was specifically on the issue of discrimination against 1950s women in the context of the 1995 Act changes to the date or the birthday upon which the age pension was to be paid to women. And from 1940, women had received the pension at 60. Men had received it at 65. When the change was made to equalise women with men, the age of which women gained the pension, it was the women born in the 1950s who were targeted to bear that change specifically. Of course, in the end, all women will now receive the pension at 65, or it's now 66, just as men are receiving at that age. But the transition period is the period during which women born in that decade of 1950s were directly targeted on the grounds of sex and age, and those women were never advised, or were advised only very late in the day, some of them, that the change was coming about. And that meant that they were left in the lurch, because many women were expecting the pension, of course, at 60, and it simply did not come at 60. And that is what the tribunal looked at, hearing from witnesses, women who had been directly impacted and the way in which it had affected them, their lives. And we also heard from expert witnesses, including Dr. Elgin Savarov, who is the deputy chair of the CEDAW committee that sits in Geneva. And his expertise is, of course, in discrimination law. And he gave evidence on this issue of discrimination against women in terms of well, the employment impact, the retirement impact, the way in which they had to reorganise their lives in order to deal with this issue of change, which came for them at a time when they had not been properly or not informed at all of the change.
Okay, and I understand from that you came to some quite important conclusions for 1950s women.
Yes, in a judicial review was run by the Back to 60 or the 50s Women, and the court that heard the review, the High Court, the Court of Appeal, actually said that it was not women who were discriminated against, it was men. Now, if one looks at it, of course, women were getting it at 60 and men were getting it at 65. But men weren't being discriminated against in the 1995 Act changes and the administration of the Department of Works and Pension in relation thereto, because men just continued their lives knowing that they were getting a pension at 65, and then when it went up to 66, that was when the department started notification when it affected men. But the women were impacted by the change, and the way they were impacted was twofold, absolutely. And there's a potential third way in which some were impacted. They were impacted directly on grounds of sex, because the men did not have to do anything in terms of rearranging their retirement plans or rearranging their employment plans. But all the women in the 1950s had to. They had to rearrange their employment arrangements, try to hang on to the job that they had or get another one. And they had to reorganise their retirement plans. That is, they'd planned to retire at 60, and now that was not going to happen. They had to remain in the paid workforce until the pension accrued to them. And that was not required of any man. Therefore, that is sex discrimination on a direct basis. It was also age discrimination, because within the change, the schedule, some women got the pension on their birthday at 61, 62, 63, but many of them did not. And there was a schedule that said, say, this is just an example, women born in 1953, some of them would get it when they turned whatever the relevant age was at that time, no longer 60, but the age at which they then were to get the pension. But a lot of them, and in fact most of them, didn't get it on their birthday at all. They got it weeks after or months after, so that there was this schedule that meant that there was an age discrimination, and that impacted as to when they had to continue working in their paid employment or scrabble about trying to find another job. And it impacted on age grounds as to when they would be able to retire, and therefore it impacted on their retirement plans. The third way in which there is potential here, this is indirect discrimination, is that women who gain divorces, and explicit evidence was given on this to the tribunal, that women went through divorces and what was taken into account was the pension as if they were going to receive it at 60, when in fact that was not correct. And so it appears that it was not only women who were not informed, but the judiciary didn't know, barristers didn't know, representatives of these women, because their divorce settlement in property terms took into account the pension accruing to them at 60 when it didn't, and it wasn't going to. And therefore that can be indirect discrimination, because there's a differential impact on those who are going through divorce proceedings. But the principal ways in which the discrimination came about was A, sex, because women, not men, had to rearrange their employment plans and their retirement plans and age, because within that cohort born in the 1950s, there were different times at which they would eventually gain their pension. And in terms of age and men were still receiving it at 65 and then 66. And of course, the delay in or failure to notify impacted on the vast majority of the 1950s born women. It's hard to find any of them who were actually notified. And when the notification came, to the very few to whom it came late in the day.
Thank you, Dr. Scutt. Now, given that there is discrimination and it is illegal to discriminate against one gender or another, I've seen a quote from you about what should now happen, who is obliged to do something about this. Could you just remind me of that quote that you gave at the time?
Yes, and I'll read it. Government and Parliament have a responsibility to face up to and to acknowledge the grave wrong done. There is no room for obfuscation or quibbling. Historical discrimination requires relief. There is a moral imperative to right this wrong. The law is on the side of 1950s born women. 1950s born women alone are the group that was targeted. This is a debt of law and a debt of honour, and full restitution is the only proper, ethical and moral outcome. Full restitution must be honoured. And ironically, if I can add here, every government since 1995 was when the Act came in, but it was 2010 when the Act began to be implemented by the Department of Works and Pensions, when they began doing the calculations that led to the women not receiving it at 60. And that means that since 2010, women born in the 1950s have been suffering this disadvantage. That's 13 years ago. And it's more than timely that each government, there's always been an acknowledgement by each government, whether it's been the Labor side or the Conservative side, that a wrong has been done here. And there have been ministers, the Prime Minister Boris Johnson, when he was the Prime Minister prior to an election, said that he agreed that action had to be taken. And in terms of the Labor opposition, there was an acknowledgement that 59 million needed to be set aside to address this issue. Now, that might seem like a large sum, but the point is that that large sum has actually been paid into the pension system by the 1950s women who have not been able to take out of the system the monies that they paid in, and that was their expectation that would be paid to them. Now, we know that the way that pensions work is that one pays in, and the money that is being paid in today is paying for the people who are retiring today, and the people paying in now are paying in on the expectation that in the future, when they reach the retirement age, they will gain the pension because they've contributed. And that contribution is being ignored by both sides of politics.
Yeah, as you say, Jocelynne, this has gone on for far too long and affected 3.8 million 1950s women for far too long. So let's give them some hope. Let's talk about ways in which we could see a resolution to this issue. Now, I understand that Garden Court Chambers, for those of you who don't know, they're a #1 ranked barristers' chambers. They're committed to fighting injustice, defending human rights, and upholding the rule of law. They have offered to act as an impartial broker to bring about mediation. Can you just tell the victims, the 1950s women, what they can expect from a mediation process and how that would work?
Right. In the law, one can go directly to court and litigate a matter, but there's a process called alternative dispute resolution. And this is commonly used in commercial matters or in building matters, in all sorts of matters. And this, as I understand it, is the proposal here, that there be a mediation process, which is alternative dispute resolution. And what happens there is that there is a neutral mediator, and my understanding is, as you say, Dr. Lloyd, that Garden Court Chambers has approached the government offering their services to be an impartial mediator in this matter. So they'd be the impartial mediator, and representatives for the 1950s women would come to the table with the government to discuss the matter with the mediator, ensuring that both sides had equal time, that the issues that were of concern to both sides could be on the table and discussed. And out of that possibility and out of that process, one would hope that an agreement could be reached as to how the 1950s women could be properly compensated, and how this egregious wrong, that's a wrong under international law also, that is, it's a breach of CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, and that cannot be ignored because this country signed up to CEDAW, it has signed the optional protocol under which action can be taken, it reports to CEDAW on a regular basis, and the law is the law of this country, and it can't be ignored by courts and it can't be ignored by government. So that's what the government needs to take into account, that there is this proposal being put by mediation experts, Garden Court Chambers, to really enable both parties to resolve the matter justly for the 1950s women.
Gosh, that sounds really promising. And I do hope that we may hear more of that in the future. But can I just bring you back to something that 1950s women might know about? And that's the fact that currently the Ombudsman, Rob Berens, is looking at maladministration regarding the pensions for 1950s women. And I'd like to just give you a quote. I'll read you a quote from him. He says, "My duty is to provide the right outcome for all 1950s women and to ensure justice is achieved." Wonderful quote, wonderful hope. What is your expectation from his long-awaited report, which I think now is very overdue?
Well, the right outcome and the achievement of justice is not located only in the delay and maladministration proposition. My understanding is that before the Ombudsman, the complaints of 6 women who have been impacted by this change and who were impacted by the delay on the part of the Department of Works and Pensions in informing them of the change. And I don't think that there's anybody who would put forward seriously the proposition that there was no delay. There was, and it's been acknowledged by both sides of government. And he therefore can't, in his report, in my submission, he can't properly, justly resolve the matter because, as I say, it goes beyond the delay and the maladministration. And that's why alternative dispute resolution, the mediation, is essential, because we don't want the 1950s women rights to go down the wrong path. We don't want them to be deprived of the rights that they have and what they're really entitled to. They're entitled to more than some, minor sort of compensation that's based in some notion of delay. Yes, there must be compensation for that. There's no question about that. But the compensation has to go beyond the question of delay. And that's what can be addressed in alternative dispute resolution through the mediation process.
Thank you, Jocelynne. So you've explained very well the two different avenues that are currently being investigated. Can these two things, the PHSO report and the ADR for dispute resolution, can they coexist when required? Is that possible?
Well, one of the major problems here is that if the government uses the ombudsman process to try to wiggle out of the very real possibility to address the matter by mediation, then they're simply adding to the delay. As we know, it was 2010 that this problem began in terms of the direct impact on the 1950s women who were targeted. It's now 2023. That's 13 years that this has been going on. And the government, therefore, would ironically be adding to the delay, and that delay really should be taken into account, I suppose, by the Ombudsman. But as the Ombudsman has before him a very discrete issue relating to 6 women and how the delay impacted on them, then it can't be used as an excuse not to address this much bigger issue of the CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, and the egregious wrong that's occurred that is a breach of CEDAW, that's a breach of the 1950s women's rights, and the direct targeting of them as the group that was going to be impacted and was impacted for the transition. So for the government to turn its back on alternative dispute resolution, mediation, saying, well, we can't do that because the Ombudsman is in his process, they are, as I said, simply adding to the delay, and they're adding to the distressed circumstances of the 1950s born women. And that distressed circumstance is clearly in the government's view, and it's clearly in the opposition's view. It's clearly in everybody's view if they only open their eyes and listen and look and read the judge's report from the tribunal, if they also read the report from the People's Tribunal back in 2020, and if they simply listen to the women who've been demonstrating. And I understand there have been early day motions, there have been petitions, and members of Parliament have signed them or put forward early day motions. So therefore, nobody really in their right mind can say that they don't know that there's this issue and that it's one that is continuing. And the proper approach is to go to mediation and address the matter, not hide behind the delayed report of the Ombudsman.
Right. So what you're saying then, Jocelynne, is that mediation which is what CEDAW in law is asking for all 1950s women, can proceed irrespective of the Ombudsman's investigation.
There's no question, because the Ombudsman, as I said, can't deal with the whole injustice, can't deal with the whole of the compensation that's due to the women. And the Ombudsman is focused on 6 women who've brought their concerns about the delay and their evidence about the delay to the Ombudsman. There are 3.9 or 3.8 million women out here who are impacted and who need to be taken into account.
Yeah, unfortunately, fewer than that now. That was when we started. So many women have died before we've got any resolution on this, Jocelynne. So the numbers are lower than that. what would you like to say now as we conclude to all the 1950s women out there and who are listening to this?
It's very hard to say anything that will be sufficient to address the issue that they're facing and that they faced over this egregious action that's been taken, and the neglect. If one says sympathy, then what use is sympathy? If one says the government must act, what use is that if the government fails to act? If one says, well, wait until the general election and have your votes count, of course, that matters. But why should they have to wait for the general election when they can use their vote? They're members of the community who have rights. And because they were born in the 1950s, there seems to have been this idea that 1950s women, you see, would simply be quiet and go away, and that there wouldn't be any uproar. Well, there is an uproar, and all I can say is I have huge respect for all the 1950s born women who have been making an uproar, who have been making it very clear that they have rights and that they demand that their rights be, that their issues be listened to and that their rights be taken into account, and not simply taken into account, but be redressed. That's what I would say to 1950s women. And what I would say to the government is, get yourselves to the table, take the opportunity that Garden Court Chambers has offered to you so that you can act with a proper moral courage, with an ethical approach, and in the context of the legal requirements that really are facing you as a government.
Yeah. And in the meantime, Jocelynne, as I know you've said before, what 1950s women can do is keep on at their MPs. MPs need to be re-elected, as you have stated. Ask them, call them to meet for mediation. Sign, please, our e-petition calling for ADR now, and invite their networks, with their own networks within social media, to do so, and their networks, etc. And follow us on @2020 Comms and amplify our output. Now, can I just say thank you so much, Dr. Scutt, for everything that you've done. I'm sure 1950s women out there will be delighted to hear that we are still making progress. We are still trying to get the justice that they so much deserve. And they can follow further developments on our website and our Facebook page. And details for all of that will be below this video on YouTube. So it will be in writing so that they can follow it up and make all the contacts. Thank you so much for your time.
Thank you, Dr. Lloyd. Thank you, Davina. Thank you.